Good afternoon, everybody. Today, we're going to be taking a look at affirmative action. But before I look there, I want us to be quite clear on what it is that we've looked at so far in these earlier civil rights videos, and that is on the legacy of racism and sexism. And that is something that affirmative action programs, both executive orders, was meant to address. What I want you to see is that both of them talk about taking affirmative action to ensure applicants are treated equally without regard to race, color, religion, sex, or national origin. So it's far broader than simply race now, and it's expanding to other social groups, which is why the last video did look at other social groups. But this next executive order goes a little bit further and focuses on the whole Department of Labor and talks about government subcontractors taking active steps there, not just government jobs, but those that are contracting with government jobs as well. Local agencies and contractors are going to have a very different interpretation of what that ultimately means. And the first way to interpret it, one of the ways that a number of organizations viewed it was to use quotas in hiring minority groups, be they women or people of color. And that was ultimately challenged with this particular case of UC Regents versus Bakke. Put simply, the court case determined that the use of affirmative action programs is ultimately constitutional. However, the use of quotas is not. To clarify what that means is that in this case, the UC Medical School, in this case, the UC Davis Medical School, was setting aside a certain number of seats for minorities. And Bakke here was ultimately challenging that practice of the university, arguing that his GPA and his eligibility for the program surpassed that of the other applicants, ultimately arguing that the quota system violated his equal protection rights under this system. I hope that ultimately what you're hearing here is another argument based on reverse discrimination, something that you saw in the Shavi Reno case. And that would also be used in the Adirond constructors versus Pena. And that is a case that actually took place in California. And what I want you to notice here ultimately is that it's based on reverse discrimination. What I want you guys to argue is that there are some who argue that claims of reverse discrimination, that isn't real. There is no such thing as reverse discrimination. I wonder what your take on that is. California certainly has felt that it's a very real thing and that a number of groups have been hurt by this. And you can see that in 1996, California passed Proposition 209. What that effectively did was end using affirmative action programs in the state of California. In theory, that it was what it was meant to do. However, in practice, it was interpreted a little bit differently. In other words, California began using race as one among many factors. I'm not sure what it was before that time, but it has hampered California schools' ability to recruit and have greater diversity levels at its campuses. And you can see that in the data here with the drop in Hispanics and African Americans fairly precipitous immediately after Proposition 209. However, high school graduates is still rising there, and what that ultimately means for those minority groups and where they can attend after that remains to be seen. The reason why I think affirmative action is so important is that, again, we're looking at this legacy of racism. We're looking at equality of opportunity, and we're looking at a type of issue that's affecting many of you as you're applying for the schools that you do. How you feel about the legacy of racism or the institutionalization of racism at these universities very much has to do with your views on something like affirmative action. I'll go ahead and end there. I appreciate your time and hope you found this informative. Bye, everybody.